Hi, very good morning. This is again a interesting Supreme Court judgment. Citation is Livin Aqua Solutions Private Limited versus HDFC Bank Limited. Small mistakes may cause you big problems in courts. That is the main thing. So, issue is a Section 7 application was filed under Section 7 application under IBC was filed by HDFC Bank against the uh, Live in Aqua Solutions Private Limited. So this application was verified on 26/7/2023. Unfortunately, the affidavit was deposed on 17/7/2023. It is simply put, affidavit date was earlier, application verified date was later. This is a mistake committed, maybe inadvertent error. Now, the before the NCLT Live in Aqua Solutions Private Limited, that is hereafter I will call it as big name. So Live in filed an petition saying that this application itself is not maintainable because the affidavit date is earlier, application verified date is later, which is erroneous. So application itself is non-est. That is the contention of Live in. NCLT agreed with the submission of Live in and dismissed the application filed by the HDFC Bank. They said your application is not maintainable. Naturally, there is a default. Otherwise, HDFC. So I need not have to say all those things. They took a loan. Livin took a loan. HDFC Bank as the Livin failed to repay the loan. So HDFC Bank filed an application before the NCLT. So now, because of that single reason, affidavit is affidavit date is before, whereas application verified date is later. On that ground, NCLT said this application itself is not maintainable and hence dismissed it. Then HDFC filed an appeal before the NCLAT, that is Appellate Tribunal. Appellate Tribunal allowed the application of HDFC. NCLAT reasoned that when an application is filed with a defective affidavit, it would not be non-est as the said defect can be cured. So NCLAT, what it did was it returned the application to NCLT and directed NCLT to hear the matter on merits. That is the order of NCLAT. Now, Livin filed an application before the appeal before the Supreme Court against the order of the NCLAT. Supreme Court noticed that in this case, a consolidated notice under Rule 28(4) of NCLT Rules was given by registrar to many parties to cure the defects in the applications. No notice was given under Section 7(5)(b)(c) of IBC to the HDFC Bank. That is the requirement. Section 7(5)(b) of IBC requires notice to be given to the applicant himself to rectify any defect. Suppose if you file an application and section sees any defect in that application along with that affidavit, then it has to give a notice to the applicant himself. That is the requirement of section 7(5)(b) of IBC. Another rule is there, that is Rule 38(5) of NCLT Rules, provides that notice can be served even on an authorized representative. On that basis, registrar has served the notice to some 40 companies for defective filing. Supreme Court said that notice to authorized representative is not enough to satisfy the mandate of Section 75B of IBC. IBC being substantive legislation, notice must be given under that section to the applicant. The compliance with the rules framed by NCLT is not enough because IBC is the substantive legislation. Rules are only subsidiary, subservient to the section. So it said you cannot follow the rule, you follow the section. That is the order of Supreme Court. The argument of Levin that defective affidavit filed in support of application is liable to be rejected on the ground of being non-honest. This submission was rejected by the Supreme Court. Supreme Court held mere defective affidavit in support of application will not render the very application non-honest. Supreme Court said it is neither an incurable defect nor a fundamental defect. It's mere error, mere defect. Then Supreme Court noted down its earlier judgments, which said rules of procedure are made to further the cause of justice and not to uh, provide hindrance thereto. Non-compliance with any procedural requirement should not entail automatic dismissal or rejection unless the relevant statute or rule so mandates. So, if there is a defect in procedural, it will not result in automatic dismissal unless Supreme Court is very clear on that. Unless the relevant statute or rule so mandates. If the rule or statute so says, then it will be dismissed. Procedural defects and irregularities, which are curable, should not be allowed to defeat the substantive right to cause injustice. Procedure is a handmaiden to justice. So, it should never be made a tool to deny justice or perpetuate injustice by any oppressive or punitive use. Supreme Court did not accept even though it said all these things, it did not accept the direction of the NCLT, which directed the NCLAT, which directed NCLT to hear the matter on merits without curing the defect. So the direction, if you remember, NCLAT said, no, 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 you hear the matter on merits. That is the direction given by NCLAT to NCLT. Supreme Court said nothing doing. If there is an error, there is a defect, that must be first purified. And then you should hear the matter on merits. So Supreme Court directed HDFC to cure the defect. And then NCLT will hear the application on merits. That is the order of the Supreme Court. So the thing is, small mistakes. Here, if you see, it's a minor mistake. Affidavit is earlier in date, verification is later. So, slight error. I would say it's not even a defect error. It may be inadvertent, but you should not underestimate the opposite side. So he has to travel from the lowest court, that is NCLT, to highest court, Supreme Court, just to entertain this application. Again, the application has to be heard on merits. So certain things uh, have to be, the advocates have to be very, very careful because the opposite side may come up with a googly and then off track the case. That is the main thing. Thank you very much. Have a great day.